Yeah, hi Linda, you're the first. Yes, hi there. Seriously though, I struggled to think of a title for this because this is just so appalling. This one article, the second article, and I'm sure you'll see immediately the connection, the similarity with what's going on in Wisconsin with regard to Steve and Brendan. Although there's not a direct connection, or even in some ways similar, but I think you'll get the connection. I'm pretty sure you will. So just to recap, my Sunday night, 9 o'clock, doing a chat with Mark, and we'll go through some more of the advocacy foundation for the dude. I found, as you can probably see, I found a few videos, old videos of the dude. I particularly like the one where he sent me the him doing the werewolf. I'd been on about it. I'd been on at him for ages, and he eventually sent me that. Anyway, let's have a look at a couple of articles. Let's not waste any time here because I'm in the middle of teaching, and I've still got some more lessons to do, but I've got a little bit of a gap here. So let's just pop up the first one here. Let me just make sure everything's working fine. It seems to be working fine. Just make sure everything's lovely. Okie dokie. So, interesting. This is by Barbara Haggerty, and I'm sure that Jim Haggerty is a reporter who has done articles about Steve and Brendan. In fact, I'm pretty sure that's the case. Anyway, this is January 28th, 2021. An awful mistake might soon be fixed. Finally, Benjamin Spencer is the luckiest of the unlucky. Let's have a look and see what we're saying here. So there's Benjamin Spencer. What does it say about him? Oh, let's get that out of the way first of all. Benjamin Spencer at the HH Caulfield unit every morning. So let me just make that a bit bigger. There we go. Every morning, long before dawn, Benjamin Spencer slips out of his bunk, dresses quickly in his white uniform, and heads to his job. He tiptoes so as not to wake up the 110 men in his dorm room, men who have been convicted of murder, rape, drug trafficking, and other violent crimes in one of the most dangerous maximum security prisons in Texas. For nearly 34 years, Spencer, who is black, has served time for a robbery that resulted in the death of a white man, a conviction he insists is an awful mistake. And in this, he is not alone. A Texas trial judge, the foreman of the jury that convicted him, independent investigators and attorneys, alibi witness, not to mention 3 of the 4 witnesses who testified against him, have all said that Spencer had nothing to do with the assault. None of that has mattered. According to Texas courts, Spencer is a criminal who should die in prison. Come on down. Yet that may soon change. After an exhaustive investigation, the Dallas County District Attorney, John Clouseau, we'll go for, sounds a bit like Jean Clouseau, Inspector Clouseau, Jean Clouseau, now believes that Spencer did not receive a fair trial. Spencer is expected to walk out of prison in the next few weeks. Bit like Steve. This is a remarkable turn of events in a system that emphasizes the finality of convictions over the possibility of innocence, in which Convicting an innocent person is easy, and undoing a mistake is close to impossible. Let's come on down. Spencer's misfortunes began on March 26, 1987, when he was arrested for robbing and killing Jeff Young, a 33-year-old executive with a wife and 3 children. After a 4-day investigation, police concluded that Spencer and another man, Robert Mitchell, had bludgeoned Young as he worked late in his office in the warehouse district of Dallas. The men allegedly stuffed Young in his BMW, drove into the poor neighborhood of West Dallas, and dumped the victim, who was still alive at that time, in the middle of the road. They then, according to police, parked the car in an alley and ran away. No one saw the assault, but Gladys Oliver, who lived near the alley, told police that she'd spied Spencer and Mitchell dash away from the car, even though the street had few lights and the moon had not yet risen. Spencer, 22 years old and newly married, with a baby boy on the way, had no record of violence. No physical evidence connected him to the crime. None of the fingerprints found at the crime scene or in the car matched his. The police found none of the stolen items in his house. They never found the murder weapon. Spencer also had an alibi. A neighborhood friend testified that she was with him when Young was killed. The state's case relied entirely on the eyewitness testimony of Oliver, 2 young men who backed up her story, and her jailhouse informant who insisted that Spencer had bragged about the crime when they shared a cell. Wow, that's a novelty, isn't it, eh? Today, oh, too far, too heavy with my right index finger there, I'm afraid. Today, even the prosecutor says the evidence was astonishingly thin. I'm reading the trial transcript and I walk away going, how in the hell did I get a conviction? Andy Beach, who prosecuted the case nearly 33 years ago, told me last month. I mean, absolutely, there's reasonable doubt. But Frank Jackson, Spencer's attorney, believes that the guilty verdict was inevitable in 1988 Dallas. It's hard to overcome a dead white guy who's killed by 2 black men in a black area of Dallas where you dump his body out on the street, he told me in 2017. It's just hard to overcome that kind of emotional case. Spencer was sentenced to life at the H.H. Caulfield Unit, a maximum security prison, in 1988. During the first 12 years of his imprisonment, he appealed to everyone he could think of: attorneys, politicians, scientists who could debunk the eyewitness testimony. He struck out. I think that's a baseball term, meaning he didn't get any luck. What are the chances a convicted killer is innocent? And anyway, how do you prove it? There was no DNA in the case that could be tested to exonerate him. Only one person, a lay minister in New Jersey by the name of Jim McCloskey, responded to his plea. In 2000, Spencer received a visit from McCloskey, as close to a godsend as one can imagine. McCloskey founded Centurion Ministries, the first national organization to reinvestigate questionable convictions. He is considered the father of the modern innocence movement. He won his first exoneration as a Princeton seminarian nearly a decade before the Innocence Project was launched, and his work has exonerated more than 60 people, some just days before execution. McCloskey, I think I've come across him, but I wonder if that's the same fella that Saul Kassan sent me articles about. It's got that Gaelic ring about it. McCloskey, Irish or Scottish. Anyway, so Jim McCloskey, yeah, I'm sure it was Jim, yeah. Jim McCloskey took Spencer's case, tracking down witnesses, discovering evidence pointing to another perpetrator, and finding scientists who stated that no one could have identified Spencer on that dark night. He and Cheryl Watley, an attorney, presented their evidence to the Dallas trial judge in 2007. A year later, the judge found that Spencer deserved a new trial based on actual innocence. Huh. 3 years later, he's had to wait 3 years. Spencer discovered that even a declaration of innocence doesn't guarantee a new trial. In this, Texas takes a philosophical page from the U.S. Supreme Court. In a 1993 decision, Herrera versus Collins, the High Court ruled that a claim of actual innocence does not entitle a prisoner to a new trial, even in death penalty cases. In 2011, Texas's Court of Criminal Appeals, the state's highest criminal court, denied Spencer a new trial. It ruled that there was no newly discovered evidence, that is, most commonly DNA, to definitively prove that Spencer was innocent. Texas judges called this standard a Herculean task. Paradoxically, the result was that the very absence of forensic evidence against Spencer, no fingerprints and no DNA connected him to the crime, is the very thing that kept him in prison. Indeed, for every Ben Spencer, legal experts I spoke with say there are thousands, perhaps tens of thousands, of innocent men and women with no DNA to prove their innocence. Thanks to CSI and its crime show Progeny, the public has often come to expect DNA to solve most crimes perfectly and quickly. But at about half of the crime scenes, no usable DNA is collected. After the ruling in 2011, Spencer faced the near certainty that he would live out the rest of his years in prison. He had exhausted all his legal appeals. He never again visited the prison's law library, where he had searched for a legal fingerhold. He stopped working out at the prison gym. He began skipping church. Although his faith remained strong, his letters to his friends and family, once a daily torrent, slowed to a trickle. Poor guy. In May 2017, in search of a story for The Atlantic, I called up McCloskey, whom I knew from my reporting days at NPR. "What's the case that haunts you?" I asked. "Oh, that's easy," he replied instantly. "Ben Spencer's case. There's probably not a day that goes by that I don't at least think of Ben." Over the next few years, a pro bono private investigator named Darrell Parker and I followed in McCloskey's footsteps. We discovered new exculpatory evidence. We found a new alibi witness, never called at trial, who saw Spencer with his sister at their home at the time the victim was being bludgeoned miles away. One of the three eyewitnesses, Jimmy Cotton, eventually admitted that he never saw Spencer that night. Another eyewitness, who had died years earlier, told a friend we interviewed that he'd lied to get reward money. We tracked down the jailhouse informant, Danny Edwards, who blithely stated that Spencer had never confessed to him. Edwards had lied to finagle himself a lighter sentence. "Nah, he didn't do it," Edwards said. "In my heart, he didn't do it." All the evidence against Spencer had collapsed, except for Gladys Oliver's testimony. When I spoke with Oliver at her apartment, she began to cry and claimed she couldn't remember anything because she has dementia. We published the results of our investigation in the January-February 2018 issue of The Atlantic, accompanied by a 3-part podcast. A magazine article, of course, carries no legal weight. In the end, whether Spencer would die in prison boiled down to this one thing: political serendipity. Political serendipity. John Cusack, a progressive black Democrat, was elected as the district attorney of Dallas County in November 2018. He reopened Spencer's case, the first DA to do so in the 3 decades since Spencer's conviction, and assigned it to the Conviction Integrity Unit. Cynthia R. Garza, who heads the unit, read every document in the files, followed new leads, interviewed witnesses, gathered affidavits. When she emerged from her deep dive, she had unearthed several pieces of evidence that Spencer had received an unfair trial. Garza found conclusive evidence from the jailhouse informant's wife at the time that the informant had made up certain details of Spencer's alleged confession. Garza secured an affidavit with Cotton, as well as a polygraphed interview that he passed, in which he said that he never saw Spencer at the crime scene, but was pressured to say that he had by his middle-aged neighbor and the state's star witness, Oliver. Crucially, she found that Oliver had received $5,000 to $10,000 in reward money and had lied about it at trial. That admission came from Oliver's own mouth. According to court documents in 2010, she told 2 prosecutors who weren't involved in the original trial about the reward. Garza interviewed a colleague of the victim who told Garza that the victim's father had said the victim's company paid a woman whose description the investigation found matches Oliver's $10,000, a corroboration by a man who had no dog in this fight. Finally, Garza came to believe that the prosecutor, Andy Beach, had suppressed exculpatory evidence. The state knew Oliver expected to receive thousands of dollars in reward money, and the evidence should have been turned over to Spencer's lawyers. Had Spencer's original lawyer known that Oliver had incentive to identify someone, anyone, for the crime, he could have undercut her credibility at the trial. Beach disputes this. He believes the defense was aware Oliver had an incentive to testify. You would have to be a Martian not to understand Gladys hoped she would get the reward, he wrote to me in an email. Wanted the reward, needed it. I didn't disclose Gladys expected the sun to rise from the east the day after she testified, so I guess I should have done that. Last week, on January 21st, nearly 34 years after Spencer was shackled and incarcerated, the DA's office found 5 grounds or reasons to justify relief to grant Spencer a new trial, asking the court to see that justice is done. The district attorney's office declined to comment for this article, as did 2 members of the victim's family whom I contacted. The family still believes that Spencer killed Jeffrey Young. The victim's oldest son, Jay Young, recently told me. In a 27 interview, Young told me that the family is exhausted, frustrated that every few years they're forced to relive their father's murder. Sometimes people look at this as winners or losers, based on decisions by public figures, the DAs, the judges, the courts, the criminal appeals, he told me. That's never going to change the fact that we are the losers here. We lost our father. For me, as a journalist who has spent nearly 4 years knocking on doors across Dallas, interviewing scores of people, from judges to snitches, marking every legal turn and inhaling every breath, I feel both elated and deflated. Great, he will be released. When a prosecutor scrutinized the evidence, once considered rock solid, it scattered to the wind like dandelion fluff. But why did the police and other prosecutors, DA after DA, and every judge but one look askance at the glaring problems with this case? Why did they punt as Spencer watched the best years of his life drain away, leaving his wife alone to raise their son, his son without a father to teach him to swim and to drive, to launch him into adulthood? District Attorney Crusoe is expected to join Spencer's defense team. McCloskey, Watley, and another pro bono attorney, Gary Uderson, to petition for a new trial. After nearly 34 years, a new trial is unlikely. The charges would probably be dismissed. And while they wait for Texas's highest criminal court to agree, a realistic possibility, since this time the DA is siding with Spencer, not opposing him, Spencer would be released on his own recognizance, probably in February. Ben Spencer is the luckiest of the unlucky. He's lucky because a non-profit organization spent some $250,000 on reinvestigating his case. Lucky because of Dallas's most prominent lawyers donated their time to litigate his case. Lucky because The Atlantic, among other media outlets, brought his case to light. And astronomically lucky that the district attorney reopened his case, even though there was no low-hanging DNA fruit to be plucked. How many innocent prisoners, particularly those with no DNA in their files, draw this sort of legal and media power? About as many right crows live in Central Park. None. This is a partial victory for Spencer, a ruling that he received an unfair trial does not exonerate him. His name would not be cleared. He would not receive compensation from the state for unfairly trying and convicting him, for stealing his years from young adult to middle age. Proving innocence could come later, but for now, Spencer's team wants him out of prison, where the coronavirus is rampaging. No one feels the urgency more than Spencer, who is trying to remain socially distant in a room with 110 others. For the moment, Spencer is focusing on surviving the next few weeks before his release. He's lost 25 pounds, hope and anxiety having robbed him of appetite. But he has plans. He wants to renew his driver's license. He wants to rebuild a car with his son, now 33, a hobby they share. He'd like a Burger King Whopper, which, unlike everything else he will encounter, is probably still the same 34 years later. He's hankering for some round-toed ostrich boots to replace the beloved snakeskin boots he was married in 34 years ago. More than anything, he wants to remarry his ex-wife, Deborah. Facing a life sentence, he had persuaded her to divorce him so she could find another love and build a new life. He wants to spend time with her, maybe just sitting on the couch, watching a movie. He's going to catch up on a lot of Netflix, whatever that is. Brilliantly written, fantastic article. Here's another one, very, very brief. Innocence Project. This is the cover picture. In 2006, despite telltale signs of a wrongful conviction, the state of Tennessee executed Innocence Project client Sedley Ali without testing DNA evidence that may have proven his innocence. Today at 1 o'clock, so that was 2 days ago, lawyers for April Alley, that's Sedley's daughter, will argue before the Tennessee Court of Criminal Appeals for the right to finally test the evidence. Will you tune in to watch the live hearing from us? It's on YouTube. You can go and watch it. It's easy to get. Here is Sedley and April Alley. The courts refused to test the evidence before Sedley was executed, but years later, in State versus Powers, the Tennessee Supreme Court admitted its basis for the denying the testing was wrong. Yet April's petition to test the DNA after her father's death was still denied by the court in 2019. The argument today is an appeal resulting from that decision. In 1985, Sedley was convicted of the rape and murder of Suzanne Marie Collins, despite weak physical and eyewitness identification evidence against him. The tire tracks found at the crime scene were not from Sedley's vehicles, and recovered shoe prints did not match his shoes. Key eyewitness accounts also don't match Sedley's description. He told April and members of his legal team that he was coerced into confessing to a crime he didn't commit. It's too late for my father, but it's not too late to find the truth, April said of her father's case. This is the ultimate quest for truth and justice for Sedley. So if you can, please watch Sedley's hearing, and then read and share key facts about this case with gratitude, the Innocence Project. I will include the link to that. I watched some of that. I watched quite a bit of that hearing. It was the typical garbage that you hear from the state, hiding behind the family of the victim, saying, we want finality in this. We don't want this to go any further. Look, the Innocence Project and this family, they want to know, was their father and is their client guilty? You've got the DNA evidence. You can test it. It should be tested. But no, they're hiding behind the family, hiding behind this notion of finality, that somehow you've got to eventually draw a line in these cases. No, if somebody's innocent, it doesn't matter whether it's a year later, 10 years later, 100 years later, even 1,000 years later. Let's find the truth. Yeah, let's find the truth about these things. Anyway, hi again, Linda. And hi, Jazz. Who else have we got here? Anthony. Hi, Anthony. Jazz, Linda. I suspect we're going to have maybe Jazz and Linda on most of this. But anyway, in fact, I will endeavour to... hi, JD. Yeah, I will pop the link in the description below so that you can read both articles at your leisure. Okay, I better dash, and we'll see you all, if not, tomorrow, obviously, chat with Pete. So we've got one or two things lined up with Pete that I'm looking forward to. So anyway, we'll catch you then. Usual time, 2 o'clock Manitowoc time. That's 8 o'clock in the evening for me. Thank you very much for joining. We'll see you all again soon. Bye for now.